DNA results, witnesses being threatened and circumstantial evidence. It's been a day of revelations and heated arguments at the Senekal Magistrate's Court. That's where farm manager Brendin Horner's alleged killers are applying for bail. The pair allegedly strangled Horner to death and tied him to a pole before boasting about it in a tavern. And as Govan Whittles reports, the killing has ignited pressure on government to act against farm murders while ensuring that they have the right people.
Prosecutors in the Brendin Horner murder case say the two men who allegedly killed him should not be denied or granted bail based on the merits of the case. Instead, they want the magistrate here in Senekal to only look at whether the state has a strong enough case to go to trial. They've made this appeal after admitting that initial DNA results has ruled out one of the accused from being inside Horner's bakkie, which was found 13 kilometers away from the murder scene.
Is there then not a ring of truth in the evidence of the witness that saw them coming over the mountain, if their DNA cannot be linked with the bakkie? We know that there were more attackers. Insofar as the finalization of the DNA evidence is concerned, and I want to stress it, Your Worship, that is with specific reference to the knife on the crime scene, the hat, the clothing that was seized. We know it will take 30 to 40 days. Everybody is trying to expedite the analysis. There are two cases dealing with outstanding formal investigations that must go through formal processes that I would like to refer the court to. The first is State versus Dlamini. It's a 1997 decision, the first volume of South African Criminal Law Reports, page 54, and it was of the old Witwatersrand. Here the court took into consideration that in that matter the bail application was brought one day after the incident occurred. The court considered the fact that ballistic evidence was still outstanding and an identification parade had still to be held, and bail was not granted.
The state has been criticized for having circumstantial evidence and for allowing discrepancies in the witness statements.
The information that Mr. Mayberg is relying upon is also riddled with discrepancies. Otherwise, how does one explain that the three male persons were seen coming from the direction of the crime scene by an independent witness around 6 o'clock in the morning, whereas the girlfriend to applicant number one gave information to him that applicant number one arrived at home at 4 o'clock in the morning? Surely something is visibly so wrong in that piece of evidence.
But the state also says that the accused present a threat to the investigation. They've revealed that the brother-in-law for one of the accused allegedly threatened a witness at the weekend through a third party. Judgment in the bail application has been postponed to Thursday. Govan Whittles, Senekal, Free State.